Welcome to Medmarc's Special Edition webinar series. Today's presentation is titled An Overview of PrEP Act Liability Immunity for Products Meant to Counter COVID-19. I'm Kate Klaus, Staff Attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenter, Jordan Lipp, thank you for joining us. Jordan Lipp is a partner at Childs McCune, LLC in Denver, Colorado, where he focuses his practice on product liability defense, outdoor industry defense, and commercial litigation. He wrote the book on product liability law in Colorado, Product Liability Law and Procedure in Colorado, 2nd edition, 2019, and he is an adjunct law professor at the University of Denver's Sturm College of Law. With that, I am pleased to turn things over to Jordan.
Hi, everyone, and thanks for attending. Today's topic is the PrEP Act. That's the Public Readiness and Emergency Preparedness Act. And any act with the words readiness and preparedness, the two S's, is such a tongue twister. I'm just going to call it the PrEP Act for the remainder of the session, and frankly, everyone just calls it the PrEP Act. So how I thought that we would do this presentation is I'm just going to start with an overview of the PrEP Act. I'm sure almost everyone on the call has a basic familiarity with it, but I just want to make sure we're all on the same page. Then I want to put it into a historical perspective, when it passed, how it works, and then after we go through that historical perspective, we will dive into the terminology. And understanding the terminology of the PrEP Act, as boring as the word terminology is, don't let it scare you. There are only a few words we're going to be learning. Once we understand the terminology of the PrEP Act, we'll really understand what it covers and what it doesn't cover. And then once we do that, we'll dive into the immunity provisions and the one exception to the immunity. So why is the PrEP Act so important? Why is it on the forefront of everyone's minds today? Well, among the product liability defense lawyers, there's sort of a joke email that's been circulating over the past week, and I tried to dig down to get the rights to it and couldn't figure out where it came from. So unfortunately, I don't have it as a slide for everyone. So I'm just going to describe what this joke image that's going around the defense bar has. There's a top image and a bottom image. Top image is labeled 2020, bottom image is labeled 2025. And on the top image, it's an angry crowd of men, women, and children all shouting. Some have pitchforks, and it says, "We want our vaccine, and we want it now." Now, the bottom half of the slide is 5 years later, and it's a picture clearly from a commercial. There's an overweight, older man in a suit and tie, and it says, "Did you take the vaccine? If so, you may be entitled to compensation." Right, and that's the concern of the industry, and that's the concern of everyone on this call, is that we don't have that type of a situation. As this country is facing this crisis, we want to make sure that we are getting the masks and ventilators and test kits out to the public and not having to deal with a plethora of lawsuits, a new version of the litigation that we've been seeing in so many other arenas afterwards, right? Because the company focus should be on making products for the health and safety of our country, not on worrying about lawsuits and having to deal with attorneys all the time. So that's the purpose of the PrEP Act. So let me just give it to you in a real nutshell. The concept of the PrEP Act is that it provides liability immunity to a large group of entities and individuals for the manufacture, the distribution, the prescription, and the use of medical devices, drugs, and biologics that are meant to combat a pandemic, so long as there is a public health emergency declaration by the Secretary. And spoiler alert, no surprise at all, Secretary Azar has issued that public health emergency declaration for COVID-19. So the PrEP Act is going to apply to COVID-19. So in order to really get a sense of the PrEP Act, before we dive into the terminology, let's talk about the history and the timing of the PrEP Act. So in the last 20 years, there are really four events that shaped our conversation today before COVID-19. The first one was 2003 was the SARS outbreak, different version of the coronavirus. Then 2003 to 2007 was avian flu, the H5N1 influenza, also known as bird flu. 2009 was swine flu, that's the H1N1 influenza virus. And 2014, though fortunately very limited, was the Ebola virus. So the PrEP Act was passed in 2005. So when you think about a timing perspective, this is after SARS, during avian flu, but before swine flu and before Ebola. And so when the PrEP Act was enacted in late 2005, it was controversial. And as an attorney, I always feel like any statement I have to make, I have to cite. Otherwise, no one will believe me, and probably that's the right way that the legal world should work. So when I tell you that the PrEP Act was controversial when it was passed, Saturday when I was putting together this presentation, I went onto the Wikipedia page for the PrEP Act, and when you read the Wikipedia page, it barely mentions any details about the PrEP Act whatsoever. Rather, the Wikipedia page is almost all about the controversy surrounding the PrEP Act when it was first enacted. And indeed, I have up on the screen the external links, and if you look at them, every single one deals with the controversy of the PrEP Act, not actually what the PrEP Act does. And ironically, as of Saturday morning, the Wikipedia page had not been updated on the PrEP Act since the COVID-19 pandemic began, at least in the United States. So, what was the controversy? When the PrEP Act was enacted in December of 2005, it was viewed in the media as a free giveaway or a free gift to the vaccine manufacturers. It was written as if the vaccine manufacturers had hoodwinked the public, so to speak, and are just destroying the world by getting the immunity from the PrEP Act. I think it'll be very interesting to see a year from now and 2 years from now how the Wikipedia page on the PrEP Act looks. Right, to paraphrase Yogi Berra, never make predictions, but if you're going to predict something, predict the past. Well, I'm going to completely violate that. And my prediction is that 2 years from now, when we look at the Wikipedia page for the PrEP Act, it'll be considered one of the great foresights of Congress was to get this act in place so we could help fight the COVID-19 pandemic without having to worry about too many lawsuits. Well, so with that in mind, it's going to be interesting to see how this plays out. But let's now switch gears a little bit and dive into the terminology. I know for a lot of people, for the attorneys on the phone at least, when you're looking at a new statute, it's the first time. It's a bit like your first class in high school of Spanish or French, where there's just so much new vocabulary and it can be overwhelming. Some good news about the PrEP Act for the regulatory and folks and the attorneys on this call is that first of all, it's short. It's 6 pages when you print it out, and even better yet, there are really only 2 terms that it uses that we need to learn. So the first term, and the simpler one, is a covered person. And the covered person is the one who gets immunity under the Act. And just very briefly, for those who aren't used to hearing the term immunity, immunity just basically means you cannot get sued. To put it bluntly, you can make a defective product, and you cannot get sued even though the product is defective. So the covered person is the one who gets immunity, and it is a broad definition under the PrEP Act. Please, I'm going to show a few slides that have all the language on it from the PrEP Act. I'm not expecting you to read it during this talk. I'm just providing that language for anyone who's curious afterwards. But let me run you through the basic concept of a covered person under the PrEP Act. That's the people who are immune. It's very broad. It's any manufacturer, it's any distributor, it's any prescriber, it's any dispenser, it's any component part manufacturer, et cetera, of a, quote, covered countermeasure. So covered countermeasure is the other term. So hopefully everyone now has in their mind the term covered person. That's who is protected by the PrEP Act. So now we're going to move over to what is a covered countermeasure. And this is basically the drug or device or biologic that's meant to combat the epidemic or pandemic for which there's a public health emergency declaration under the PrEP Act. Or to put simpler, this is what's being used to combat COVID-19. So with that, I'm not going to actually take these in order that the statute has. For those who read statutes on a regular basis, the ordering of statutes always seems simply bizarre. I'm going to start with the most interesting one first, and the one that's probably on most people's minds right now. Certainly, covered countermeasures include approved drugs and cleared medical devices. So we'll talk about that later, but let's just dive into the really important one. And on the screen, this is 1C. And this is the emergency use authorization. It's oftentimes abbreviated as the EUA. And basically, this originates not from the PrEP Act, of course, but rather from the Food, Drug, and Cosmetic Act. It's 21 U.S.C. Section 360 BBB-3 et sec, for anyone who's curious. And what the EUA, the Emergency Use Authorization System, allows is that the Secretary of the Department of Health and Human Services can make an emergency use declaration. And we've seen that, and we're going to go into examples in just a minute for COVID-19. But this emergency use declaration, it's for an approved drug to be used for an unapproved use. Basically, approving a drug for an off-label use, or allowing an unapproved drug to be used, or a cleared medical device to be used for an unapproved or an uncleared use, or an uncleared medical device to be used. So let's talk about terminology for a second. And I know for the folks who are on the call who are not in the medical device manufacturing realm, who are all very fluent on FDA terminology, but for those product liability defense attorneys who are on the call, right? As a product liability defense attorney, there's so many terms from each of the government agencies, and so the FDA terminology can get confusing. We already know the terms. The FDA approves, the FDA clears, and the FDA licenses. But this is the best way to think of this for folks who are new to the PrEP Act is this is a fourth set of what the FDA does. The FDA authorizes. So I'm going to use that term for the rest of the session. The FDA is authorizing the use of these covered countermeasures. And so it's a different system than we're used to with clearances or approved NDAs. We're talking about an authorization here. So to date, the FDA has authorized three categories of devices meant to combat COVID-19. So these will become the covered countermeasures, what we have liability protection for. And let me just note that for those of you who are listening to this live, the list I'm going to give you is current as of at least midday yesterday. For those who are listening to a recording of this, this presentation is going on March 31st, 2020. This is such a rapidly evolving situation, this pandemic, as everyone on the call knows, that we doubtlessly will be seeing many, many changes. So as we talk about these products, it's simple enough. Just literally, if you Google FDA, EUA, or Emergency Use Authorization, and COVID-19, you'll get right to the right page. And in fact, we will, I have for this next slide I just put up, I have the full web address. If anyone wants it, you can go and you can see what are the new EUAs that certainly this list is maybe updated while we are speaking. So there are 3 new categories of medical devices, as I said, that have been authorized by the FDA. That means that they can be used under the FDA's authorization and that they will be covered countermeasures under the PrEP Act. So the first category is test kits for COVID-19. Technically, they're in vitro diagnostic products, but the layman's terms are test kits. This was first initially authorized on February 4th, 2020. As of yesterday, by my count, the FDA has authorized 16 different test kits under its EUA authority. So if, for folks who are on the line, who are listening to this, whose company is working on test kits, the best practice is to go through the EUA request process in order to get your product covered under the PrEP Act. And the FDA has a template on its website for the submission of these EUA requests, and they're acting on them pretty quickly from everything that we can tell right now. So that's the first category of devices, is the 16 so far authorized test kits. The second set is the what I'm going to call masks, right, though their technical name is personal respiratory protective devices, which is a subset of PPEs. And I know everyone's talking about personal protective equipment, and there's more to personal protective equipment than just the personal respiratory protective devices. But the emergency use authorization right now is just for the masks, just for the respiratory devices. This was declared on March 2nd, 2012 by Secretary Azar, and since that time, the FDA has taken several steps. So first, the FDA authorized non-medical device filtering face piece respirators. What does that mean? Well, we all know that, right, there are the masks that are used at hospitals, but then there are similar masks that are being used at construction sites and factories, and those are generally regulated by OSHA, and OSHA's more scientific academic arm, which is NIOSH. So what the FDA said initially was, because we need these masks in the hospitals, we're going to allow NIOSH-approved masks, the masks that we see at factories and construction sites, to be used in the medical setting. So that was step one. That wasn't enough, so the FDA next authorized non-NIOSH-approved masks, but masks that went through a similar OSHA-style approval from foreign countries. So that was the second group. And then just this past Sunday, that's March 29th, the FDA authorized the Battelle CCDS system. Specifically, it's a decontamination machine for respirators, so we can basically reuse these masks. So as of now, right, we talked already about test kits. We're talking now about the personal respiratory protective devices, and we already have several allowed masks for that. And let's move into the third category, which is ventilators. On March 24th, 2020, Secretary Azar declared an EAU for ventilators. And as of yesterday, when I checked, there were 3 critical care ventilators and 1 ventilator tubing connector that have been authorized up to this point. So what exactly does this authorization mean, right? Most people on this call, you're familiar with what does it mean when a drug is approved, when a medical device is cleared, but what does it mean when a device is authorized by the FDA, and how does that work with the PrEP Act? Because remember, authorized devices are a covered countermeasure. Well, first things first is there are letters of authorization, and I would encourage everyone, if you're working in this industry, start reading these letters of authorization. They're available at the link that I have on the screen right now, and you'll read in these letters what the FDA is and is not allowing. So, for example, from the ventilator authorization, you do not have to follow current good manufacturing practice requirements. Now, those are words that I don't think I ever thought I would say out loud. And I'm sure a lot of you never thought that you would hear a lawyer say you do not have to follow current good manufacturing practice requirements. But considering the crisis that we're in, the FDA has actually waived the CGMP requirements for the production of many of these EUAs. Now, also, as part of these authorizations, you cannot promote an authorized product as, quote, safe or effective, unquote, which is also kind of a novel proposition for many people on this phone call are not used to hearing this. And obviously, once again, let me give the caveat, read your own authorization, because each authorization is different. I'm just generalizing here. But the authorizations also have all sorts of details in what can be put into promotional materials. For example, in the authorizations for ventilators, it says that, quote, this ventilator has not been FDA cleared or approved, unquote. That has to be put in promotional materials, which frankly sounds like the dietary supplement statements. I think I have that statement on my vitamin C and my vitamin B at home. I don't think anyone on the call ever thought that we would get to the point where medical devices, I mean literally class 2 medical devices, have the same FDA disclaimer that dietary supplements have. But that just tells us the time that we're in. So if you have an authorization for the manufacturers who are listening on the phone, please, please, please make sure that you are carefully following these conditions of authorization. So with that in mind, that is my quick overview of the emergency use authorization system that the FDA has. And this is one of the covered countermeasures under the PrEP Act. So let's go back to what, I'm sorry, I clicked on the wrong slide there. So let's go back to what the covered countermeasures are other than the EUAs. Well, subsection D in the definitions is a personal respirator protective device. Now, right, there's an old rule in dealing with statutes that why would Congress say something once in clear language if they can say it twice in conflicting and confusing language? And this is exactly what we have here. So the PrEP Act, as COVID-19 was becoming a greater health threat in the United States, Congress amended the PrEP Act to include as a covered countermeasure the personal respiratory protective devices. Now, this was already covered as an EUA, but Congress is repeating themselves now, and they have a set of rules that masks are okay, they're covered countermeasures if they are, 1, approved by NIOSH, 2, subject to the March 2nd, 2020 EUA that we've talked about already, and 3, used during the COVID-19 public health emergency. Well, this is already out of date, this statutory language, obviously, because we talked just a few minutes ago about how the FDA, in response to the lack of masks, said that non-NIOSH masks coming from other countries are acceptable. So I think we can just sort of ignore this statutory language for now. Hopefully it won't create more confusion than it was meant to solve. So now we've talked about 2 of the 3 main covered countermeasures, EAUs, and Congress repeating itself on the EUA for masks. The third one is the qualified pandemic or epidemic product. And there are other countermeasures that I'm talking about, other than the ones I'm talking about today, but they're not really applicable to COVID-19. I want to keep this simple. Simple is always a dangerous term when we're talking about federal statutes and federal interpretation of the statutes, but as simple as we can be under the circumstances. So, what is a pandemic or epidemic product? That is the third category of covered countermeasures. These are the countermeasures used to treat COVID-19 for which your company will be, or hopefully will be, immune? Well, these are first products, we're talking again, drugs, medical devices, and biologics that have been approved, licensed, or cleared, right? So let's just use the example, and I'm going to come back to this example a few times, but we think about a simple medical device, a nasal cannula, used ubiquitously in the healthcare industry. Well, if someone is in the hospital for coronavirus and they are using a nasal cannula, that is a covered countermeasure for that. And that's clearly within, it's cleared use for the nasal cannula, right? Someone who's suffering from influenza, respiratory distress. So the approved drugs, the approved devices, that's simple enough right there. The more interesting ones are the products that are going through the investigational stage. And this is a big deal. Investigational drugs and devices, right? Obviously, they have to be, have their INDA or the medical device equivalent. But if that is, then they fall within this covered countermeasure group. And then, or third, that they are subject to an EUA. Well, there we go, right? Why would Congress say something once that's clear when they could say it twice that's confusing, or now 3 times, and it becomes even more confusing? But it is, the EUA is mentioned again a 3rd time in this piece, and these are for products that are used to, whether it's a nasal cannula or one of these new test kits that's meant to diagnose, prevent, treat, cure, or limit the harm of COVID-19, or to alleviate serious side effects of the products meant to diagnose, prevent, treat, cure, or limit the harm of COVID-19, or to enhance the use of any of these products. So now we've covered countermeasures. I hope I didn't go too much into the weeds on this section. I just want to make sure that everyone on the phone, we're all speaking the same language right now. So let's move on to the immunity provision. So the immunity provision provides that covered persons are immune from suit and liability. And this is true whether it's federal court or state court, and it's all claims involving a covered countermeasure. Hopefully everyone on the call gets the concept of what is a covered countermeasure. And then if the declaration has been issued. Now, as I mentioned before, there was a declaration by Secretary Azar that was made on March 10th, 2020 as to COVID-19. And the declaration under the PrEP Act, and just so we're clear, right, you have to conceptually remember that the Food, Drug, and Cosmetic Act and the PrEP Act, they're separate acts, so there have to be separate declarations. So we have a declaration from the PrEP Act, and then we have a separate EUA system that we've gotten these, that we're putting all these covered countermeasures under the PrEP Act. I hope that makes sense. Think of it, 2 separate statutes, they're working with each other. You need separate declarations. We have those declarations here. So, Secretary Azar's PrEP Act declaration becomes effective as of February 4th, 2020, so it was retroactive, and it is set to continue through October 1st, 2024, and the declaration for COVID-19 products that are meant to combat it was as broad as the Secretary could write it. Now, even though for, I think, a lot of people on the call, you would think that this is the first PrEP Act declaration, it's actually not. By my count, there are 10 current PrEP Act declarations in place. Unless you manufacture a product related to These other PrEP Act ones, you're probably not aware of this. The only place that people are more aware of this was from the swine flu and the swine flu vaccine. That was really the first test cases for the PrEP Act. So, obviously, this is a presentation on COVID-19. COVID-19 is on everyone's minds, so that's what we're going to talk about. So, I wanted to talk now about how broad is this immunity? What is protected? What is not? Now, there are only 3 cases, and we'll get into this in a few minutes, but there are only 3 cases that I'm aware of that have ever interpreted the PrEP Act. So we're a little bit in the dark of all the exact details. That said, in the Public Health Emergency Declaration from Secretary Azar that's in the Federal Register, right, so this is administrative guidance, the Secretary provides examples of what the Department of Health and Human Services considers to fall under PrEP Act immunity and what does not. So the first example is a very obvious one, and that is a negligence lawsuit against a manufacturer in creating a vaccine. That's obvious. Manufacturer is immune under the PrEP Act. Second example is a negligence lawsuit against a healthcare provider in prescribing the wrong dose of a drug used to combat COVID-19. And so that also, right, it's interesting, it's not as much of the focus of our talk, but healthcare providers, those who administer covered countermeasures, have immunity as well. But interestingly, the third example that the Secretary gives in the Federal Register shows how broad the administration is viewing the liability immunity of the PrEP Act. And that is that it includes slip and fall or vehicle collision lawsuits by someone at a retail store to receive a covered countermeasure. So, look, this is not the greatest example, but just go with me on this one, right? So the local drugstore is selling replacement oxygen. Goes into a nasal cannula. If someone is getting that and they have, if they have the regular seasonal flu, no immunity. Someone's going there for the exact same medical device, and that is for the coronavirus, for COVID-19, then in that case there is immunity. And the Secretary described this in the Federal Register as, as the PrEP Act does not preclude a claim dealing with an injury at a site that was not directly related to a covered countermeasure. So if we're getting a product for the regular flu and you trip and fall in the store, that the PrEP Act will not provide immunity to the store for that. So those are the Secretary's examples. They carry a lot more weight than my own examples, but I want to give a few examples I thought folks on the phone might be more interested in thinking about. So let's say that you're manufacturing a COVID-19 test kit, and that test kit produces a false negative. The person takes a test, they think they're fine, they go home, and they die from COVID-19. So long as the COVID-19 test kit was authorized and acting in the scope of the authorization by the FDA, then the manufacturer of that test kit should be immune under the PrEP Act. They should be immune. The distributor should be immune. The component part manufacturers should be immune. That is the breadth of the PrEP Act. Let's go back to my earlier nasal cannula example, right? So for companies on the phone right now, manufacturers nasal cannulas, have been selling them for years. They go to, these nasal cannulas are being sold to a hospital. The two sets, one goes to a patient in one room who's suffering from the regular seasonal influenza virus, goes into a patient in a room right next door who's suffering from the COVID-19 influenza virus. Both people allege that nasal cannula was contaminated, and that contamination led to an infection. The patient, this is my interpretation, just my interpretation, the patient who went in for regular old influenza flu, PrEP Act does not cover that. Patient who went in for COVID-19, PrEP Act does cover that. So, medical device manufacturer will be immune from the infection claims arising from the COVID-19 patient. Now, I said this caveat before. I'm going to say it again. Obviously, one, we're dealing with an evolving situation. Two, there's doubtlessly going to be more statutory changes and more FDA guidance. And three, the courts have not had that much of an opportunity to weigh in yet on the PrEP Act. So you have to take any of my sort of crystal ball educated guesses here with a grain of salt, but that's, as a product liability attorney who's arguing this stuff in front of judges all day long, every day, that's how I see this shaping up. So, one interesting thing that I presume we don't have too many actual health care folks on the line or med mal defense attorneys on the line, but to the extent we do, I'm sure the question that you're asking yourself and that my partners who practice med mal defense work have been asking themselves is, okay, this deals with the prescription of a covered countermeasure or the administration or use of a covered countermeasure. What happens when we don't have enough ventilators at the hospital at all? And that's going to be a really interesting question and could probably be turned into its own webinar. It's one of those interesting questions under the PrEP Act. But because this call, right, we're mostly talking about devices and drugs, I wanted to stay on the device and drug piece of this. And I thought next that we should talk about the one exception to immunity. And this one exception to the immunity from the PrEP Act is for willful misconduct. So, what do they mean by willful misconduct? Let me talk generally before I go specifically. Generally, if someone's selling snake oil and the FDA somehow authorizes that snake oil, that might fall within the willful misconduct category. If not, this is a very narrow category. I don't foresee many plaintiffs, and it'll make sense to everyone as we get into the details, I don't see many plaintiffs having much success arguing that there was willful misconduct. So if Elizabeth Holmes is on this call and you're planning a new Theranos that's going to make COVID-19 test kits, I'd be worried about this exception. If, of course, the Theranos allegations are true. Otherwise, however, the willful misconduct standard is such a high one, I really don't think that we're going to see many lawsuits under this willful misconduct exception to PrEP Act immunity. So, what is willful misconduct under the PrEP Act? It is an act or omission that is taken intentionally to achieve a wrongful purpose, knowingly without legal or factual justification, and in regard of a known or obvious risk that makes it highly probable the harm will outweigh the benefit. From a legal standpoint, that's a very high standard, and then Congress made sure in the PrEP Act to say that this is more stringent than negligence, and it's more stringent than recklessness. And recklessness is a much higher standard than negligence. The PrEP Act also says that it must be shown by clear and convincing evidence, and additionally, a manufacturer or distributor cannot be found to have engaged in willful misconduct unless there was a successful enforcement action against that manufacturer or distributor by the Attorney General or FDA. So think about that for a minute. We're not only talking about, for willful misconduct, for the manufacturer or distributor, we're not only talking about this high showing has to be coupled with a successful enforcement action by the federal government. Now, that is the high standard, and then in addition to the high standard for this willful misconduct, the PrEP Act places all these additional barriers and burdens on the plaintiff trying to show willful misconduct. So, what are these barriers and burdens? The lawsuit can only be filed in the United States District Court for the District of Columbia. It must be heard by a 3-judge panel of that court for determining all dispositive motions. Any lawsuit brought, this is the complaint, must be pled with particularity. That means all the facts have to be in the complaint. It can only be filed for a wrongful death or serious physical injury, right? So my test kit example earlier, someone gets the false negative. If they die, there can be a claim. If, however, they just suffer regular old flu symptoms, they won't be able to bring a claim. The complaint must be verified. What that means for the non-attorneys on the phone is it must be signed under oath by the plaintiff. The complaint must also contain an affidavit by a non-treating physician of the injured or person or the person who's deceased that says that the injury or death was proximately caused by the administration or use of the covered countermeasure. There have to be certified medical records with the complaint showing the same proximate causation, and no discovery is permitted until the motion to dismiss that the manufacturer or distributor will no doubt file has been denied. So these are not things that I am used to, or many product liability attorneys used to explaining on the phone. The number of barriers put in place to show willful misconduct. What does this mean? It's going to be very, very, very hard for a plaintiff to show willful misconduct and to get past the dispositive motion stage in the federal district court for the District of Columbia. So is there an exception in the Act for folks selling snake oil? Yes, there is. Will it be used frequently? Probably not. And even on top of that, if the lawsuit moves forward, there are significant damage reduction pieces, such as, just by way of one example, reduction of damages for collateral sources, such as health insurance payments for a willful misconduct lawsuit under the PrEP Act. So, if someone is selling a defective device, whether we're talking about a design defect or a manufacturing defect or a failure to warn or instruct, so long as that device falls, so long as the person is a covered person, and so long as that device is a covered countermeasure under the PrEP Act, there should be liability immunity. It's only if we have this very high willful misconduct level that's hit. So, what do we know so far about how the courts are interpreting the PrEP Act? Well, to paraphrase Mark Twain, history doesn't repeat itself, but it does rhyme. We're lawyers, I'm a lawyer, I love precedent. You always look to precedent. Swine flu, as we all know, is nothing like COVID-19, but swine flu, the H1N1 influenza, gives us the 3 cases that I have been able to locate that have actually interpreted the PrEP Act. So if you go on to Westlaw or Lexis, type in the PrEP Act, you Shepardize it or Keycite it, you're going to get a list of maybe 15 cases. Of those, as far as I can tell, there are only 3 cases. So these are the only 3 publicly available cases out there that actually analyze the PrEP Act. They're up on your screen for the attorneys who are on the call if you're interested in reading them yourself. Let me give you a few key takeaways before we go into the details of each of these cases. First takeaway, not one of these cases criticizes the PrEP Act at all. There's no language like there is on the Wikipedia page about overreach, no questions about its enforceability. The PrEP Act is just there, and the courts are just trying to interpret it. Only one of these cases, the second one on this list, Keller, actually addresses a manufacturer. The other two deal with the prescribers and the administrators of a vaccine. So the only one that deals with the manufacturer is Keller. And I'm happy to report for everyone on the call that we as an industry were 1 for 1. We've won 100% of the publicly available cases under the PrEP Act, and that's the Keller case. The healthcare providers are 1 and 2. Parker was a yes, Casabianca was a no in terms of the enforceability of the immunity provisions of the PrEP Act. So let me walk you through these cases real quick, but I'd encourage you to read them on your own. I am vastly abbreviating them as I'm describing them. So Parker. So a lawsuit by the parent of a kindergartner who was inoculated with the H1N1 flu vaccine without her parents' consent. So parent sues the public health department that administered the vaccine, and the public health department argues and got support from the federal government that this was preempted by the PrEP Act. The New York Court of Appeals did agree with the health department and ruled that the lawsuit filed by the parents was barred by the PrEP Act. So great result there. Appellate decision, state court. The second one, Keller, which I mentioned a minute ago, this one's a little more procedurally complex. So there's an employee who files a lawsuit for being vaccinated without informed consent from the H1N1 virus. And he and his wife, this lawsuit consortium claim, bring a claim in state court against the physician and his employer. The physician and employer then name as a third party the vaccine manufacturer. The vaccine manufacturer removes the case to federal court and moves to dismiss it based upon the PrEP Act. The federal court kicks out the case as the vaccine manufacturer. And by the way, I was not involved in this case, but I'm going to go ahead and guess that the physician and the employer were not aware of the PrEP Act, and that's why it took this unusual procedural route. But in federal court now, the vaccine manufacturer is kicked out of the lawsuit. Claims against the vaccine manufacturer held to be barred by the federal court, and then the federal court says, look, I no longer have jurisdiction over this case, so I'm not going to decide whether the employer and the physician are immune under the PrEP Act or not. So that's the second case. The last case, Casabianca, this is the only truly bad case to any extent that's been decided so far under the PrEP Act. This is a state district court decision, though, so it's about as low precedential authority as one can get. And this was an interesting case. This was the failure of a physician to give the vaccine for the H1N1 influenza virus. This is a case of where the vaccine was out there, but had to figure out who gets it and who doesn't. And the state district court judge said that the lawsuit against the healthcare providers, this was not a covered countermeasure because the vaccine was not actually ever given. So while the vaccine would be a covered countermeasure because it was not given to the plaintiff, it does not apply. The lawsuit was about the fact that the plaintiff didn't get the covered countermeasure. So those are the three cases that we know of courts so far interpreting the PrEP Act. I'm sure we're going to have more a few years from now. But look, now that we're more or less at the end of the presentation, though I know that there are a ton of questions, I just wanted to step back for a minute and let's think about this in the big picture. Our country is going through a terrible crisis right now, as we all know, and I hope this presentation, to at least some extent, has been good news for everyone. Look, while there are many judicial tests still out there for the PrEP Act, the PrEP Act should be reassuring to manufacturers, component part manufacturers, and distributors. My job is mostly as a product liability defense attorney. I do some consulting before the lawsuit is filed as well, but most of the calls I get is after the lawsuit is filed. The same thing for many of the other attorneys, the excellent attorneys on the Medmarc Defense Panel Council, right? Most of what we do, and my fellow colleagues do a great job of this, is to defend manufacturers once they get sued. And I think the good news here is I don't think I'm going to be getting that many calls. And that's good news for all of you. And I don't think that my colleagues on the Medmarc Defense Panel are going to be getting many calls either, arising from the devices and drugs meant to counteract COVID-19, because I think the PrEP Act really does provide some very good some protections for manufacturers and distributors. Make sure that you're an authorized product. Make sure you're following those authorizations. But now, happily, is hopefully the time for all of you to focus on making good products and getting them out there to help this country through the crisis and not having to worry nearly as much about the legal ramifications. So hopefully we all view that as good news, and I look forward to your questions.
Jordan, thank you so much. That's all extremely helpful information and very clearly presented. I think it'll answer a lot of questions that our listeners have. And they have been submitting some questions, so if we can take a few minutes to run through a couple of things. I think it would be helpful to go back over really three topics. First, starting with the process and how the PrEP app actually works. And then maybe a couple of questions that have come in on who and what is covered and preconditions to using the PrEP Act as a defense, and then information that manufacturers who are new to the medical device space may need to know. So to start with the process, could we step back and look at how this would actually be used? If a company receives a claim for an injury associated with a product used in treating a COVID-related illness, what would the first steps be?
Great question. Presumably, it will not be filed in federal court for the District of Columbia. There's a process set out under the PrEP Act, right, that we talked about that would cover that where it's a willful misconduct allegation. Rather, how I see this coming in is, right, there's a product liability lawsuit filed in state court in Colorado. So because I'm based in Colorado, that's how I'm going to run through this example. So that complaint is filed. Presumably, I will remove it to federal court because federal court's probably going to be a better venue to deal with this. And right out of the bat, I am going to file a motion to dismiss based upon the PrEP Act, and I'm going to use the PrEP Act for sort of an instant liability shield. Now, frankly, what I would probably do even before that is that complaint comes in, manufacturer contacts me about this lawsuit. I'm going to call up the plaintiff's attorney, and I'm going to say to him or her, you might not be aware of the PrEP Act, so just wanted to let you know about it. Here's a statutory site. Here's some case law. Don't throw any more good money after bad and just dismiss this lawsuit. But if I'm unsuccessful in trying to persuade the plaintiff's attorney on that, then we file a motion to dismiss. And so that was more or less the process that occurred in the Keller versus Hood case. And in that case, the vaccine manufacturer was indeed dismissed and the case was over.
Okay. Is this something that could be applied differently depending upon the jurisdiction, or would it be fairly uniform across the country?
Well, just like any piece of litigation, right, we're going to see probably more lawsuits filed in the PCCP, the Philadelphia Court of Common Pleas, and some of the other jurisdictions that plaintiffs' attorneys think they're going to get a favorable ruling in, to the extent that there are these lawsuits. And will that shape things? maybe slightly, right? The Casa Bianca case that I talked about earlier was filed in New York County, New York, and so that's not the best. But hopefully there will be multiple different ways to remove these cases to federal court. And it's probably worth mentioning also that in the Parker case, that's the lawsuit by the parents, the U.S. government actually did an amicus brief in that case in support of the health department. And as we all know, it's hard to get the federal government involved, especially at only the state appellate court level as opposed to the state high court level, or often not until you get to the U.S. Supreme Court. However, the PrEP Act, because the whole point of it is designed for this type of an emergency and to make sure that everyone who's on this call is producing products that we can use in this time of crisis, I think that we're going to see a lot of support from the federal government, and hopefully we'll see a lot of support from the judges as well.
Okay, shifting over to the who and what is covered under the PrEP Act, we've had a couple of people asking whether hand sanitizer would be considered a covered product.
It's a great question, right? So the PrEP Act, and hopefully these are terms that work for most people on the call because most of us are used to the FDA products. It's the question is it a drug or a medical device or a biologic? And if it's one of those and falls within any of those covered countermeasure features, then the answer is yes, it's covered by the PrEP Act. If it doesn't, if it's not, then the answer would be no, it's not covered under the PrEP Act. So let me give you two examples real quick on this. So let's say we talk about soap. Most soaps, and obviously it depends upon what exactly is the soap, and I'm using soap in the common, not technical definition. But most soaps are not considered a medical device. They're largely regulated by the Consumer Product Safety Commission or by the FDA as a cosmetic. They're not regulated as a medical device. So those would not presumably be covered under the PrEP Act. On the other hand, Lysol is a Class 1 medical device. So Lysol, being a medical device and being used for COVID-19, should be immune. So if your company is distributing Lysol and there's some claim that you left it in the truck too long and it heated up too much and that damaged it, and therefore it wasn't effective, that claim should be covered under the PrEP Act. And hopefully that answers that question.
I think they were trying to draw a distinction between personal care products like hand sanitizers that might fall in the drug category and other household items like bleach or disinfectant products. So I think having that distinction that if it is an FDA drug or device, it is covered by the PrEP Act, but whereas typical household goods that are not would probably fall outside.
You're right. Yeah, and right, we all know that it's a fine line between what is a Class 1 medical device and what is just sort of a household product. So I would encourage anyone on the call who's manufacturing these things to make sure you know which side of that line you're on. And
if a company wants to dispute a determination that their product is not a countermeasure, is there any kind of appeals process?
Well, I think that everyone would want to have their product as a covered countermeasure, as opposed to not being a covered countermeasure, right? If you're a covered countermeasure, then you have a much higher level of protection. Now, right, we have to think of this in two different worlds. There is the litigation world, and there is the FDA regulatory world, right? And so the FDA regulatory world is the one that's going through this EUA process, but then the litigation world, which is the PrEP Act, is borrowing the EUA process to provide the liability protections. The PrEP Act doesn't protect you from an enforcement action by the government, it just protects you from personal injury style lawsuits. So for that personal injury style lawsuit area, that is where the exact scope of the term covered countermeasure is going to get tested. And it's pretty broad, as we talked about already. But I think that, there probably aren't going to be that many lawsuits, and I hope I'm right on this. I know I'm violating the old Yogi Berra maxim, but for the lawsuits that are filed and PrEP Act is used as an immediate immunity defense, courts are going to have to determine what exactly is a covered countermeasure or is not, and then with that, then we're back in the typical litigation system where the remedies for either side, if they're unhappy, is the Court of Appeals in whatever jurisdiction it is.
One question, is it only bodily injury that would be covered by the PrEP Act? What about consumer fraud or false advertising?
That's a good question. Let me just read real quickly, right? So the loss, you can't sue for a loss. That's the PrEP Act language. A loss is death, physical, mental, or emotional injury, fear of physical, mental, or emotional injury, including medical monitoring, or loss of damage to property, including business interruption loss. So, certainly if I was to see a consumer protection style lawsuit, not alleging any physical harm, I would absolutely use the PrEP Act. And my guess is that I would be more successful than not successful in getting those cases dismissed under the PrEP Act, right? Because the damage, the harm, the loss is either an injury or the fear of injury or something related to that. But it is an untested area, and there is a possibility that those style claims will make it through, even though the more personal injury claims will not make it through. So hope that helps.
With regard to the supply chain, the PrEP Act is written fairly broadly. We talked about contract manufacturers and component part suppliers, but how far down the supply chain can we go before a company might not be covered by the PrEP Act? What about packagers or sterilizers or micro-testing labs that companies may outsource to? Do we have any information on that?
So let me start with the apology for my caveat, because I know I've said this a few times. Let me say this again. Right, there's not court guidance enough on these issues, so I'm just giving you my best guess, my educated guess, having seen this play out in other places. Other people may disagree. This is Yertle the turtle immunity. It goes from the turtle on top to the turtle on the bottom, the way that this is written. The language is very broad in terms of who is a covered person, and it includes component part manufacturers. Right, at what point are we going to say that it's too low, right? Is a mining company who's pulling the materials out of the ground that then eventually make it into the medical device, are they immune? I think there's a good argument that they are under the PrEP Act. It may be a little hard to say, but I'd encourage everyone who's on the call, go to the manufacturer definition at the very end of the PrEP Act and read it and tell me if you think the same thing that I think. But I think Congress intentionally tried to write this and did a pretty good job of writing about as broadly as it can. So I think that immunity goes down the entire stack of turtles.
We have a Medmal question as well. Would the PrEP Act preclude a medical malpractice suit against a doctor who used a device that was labeled as not cleared or approved by FDA because it was made for responding to the pandemic? Yes, absolutely. That's the point of that section of the provision of the PrEP Act. Right, so some of these
devices that have been authorized under the emergency use authority that the FDA has literally have to say that, right, they're not approved and cleared by the FDA, and that their safety and efficacy has not been shown. And part of this is we want to get investigational new drugs. We want to get these authorized medical devices and drugs into physician hands as quickly as possible. So certainly the way I read the PrEP Act is healthcare providers would be immune under those circumstances. The trickier questions come, and it's when we're talking about what happens when the healthcare provider is not able to use the device, right? The healthcare provider wants to prescribe it, but it's not available. There are some good arguments for protection, but obviously that didn't hold up in the Costa Bianca case. So hopefully that answers that question.
We have a few questions as well for manufacturers who may be new to the medical device industry. There was a news item recently about a wedding dress shop that was switching over their work to make masks for healthcare providers, maybe alongside some of the gowns that they're making. Would they need to register with FDA and implement a full quality system like a typical manufacturer of medical devices would?
Oh, you're trying to get me to say again that you don't have to follow current good manufacturing processes. It's just such a novel thing to say. I struggle to get those words out of my mouth. That's a great question, and it's a tricky one. The example that I was thinking of, frankly, was I was just reading about a ski manufacturer. This is a company that makes skis in northern Michigan. It has just switched over to making masks. And how are they covered or not covered? And I think, right, as we talked about before, you have to fall under the authorization. So the question for folks who are new to the device industry is, how do you fall under that authorization? So presumably, you find who is the 510K holder, and if you're the component part manufacturer for them, all of a sudden, right, you're the ski company who's converted your line from making skis to making masks. If you're the component part manufacturer for the 510K holder, then you should be good. Now, remember, let me back up. I'm not sure I said that quite correctly. Right? If you're the 510K holder, you have a cleared medical device. So you still have to follow CGMP standards for that cleared medical device. But let's say you're making the mask under the authorization, the emergency use authorization from the FDA. If you're in that situation, and please check that authorization to make sure I'm right on the CGMP for masks, but I think I am. For that, at that point, if you're the ski manufacturer who's made, or the bridal gown manufacturer who's all of a sudden making masks, if you're making those masks under one of those specific authorizations, if you're making the component parts for the person who's authorized, you're going to be protected as at least my interpretation is that you're going to be protected as a covered person because that's a covered countermeasure. If you just decide tomorrow, I'm going to start making masks because I think it's the right thing to do, and you're not going through someone who's authorized or cleared, then I'm not sure you fall under the definition. Just my 2 cents.
Is a manufacturer's previous experience relevant? So, for example, if you have a manufacturer of car exhaust systems and a manufacturer of infusion pumps who both pivot to manufacturing ventilators, would these manufacturers be viewed differently under the law because one has experience in the medical device industry and the other does not? Is there more latitude for newcomers to device manufacturing?
Okay, if they fall under if they're covered persons that are making a covered countermeasure, then it shouldn't matter, right? The way the PrEP Act works is it shouldn't matter. Both get immunity. Could one hypothetically imagine under the willful standard that willfulness would be different depending upon how much you know, sure, that's possible, right? So if we're comparing versions of snake oil, the company that's not as familiar might be less likely to have those sort of scienter, those knowledge pieces that would show willful misconduct. But the other question is if some of these cases ever somehow make it to a jury, right? The jury system, we're pulling random people off the street and we're asking them what they think, and so which is frankly a fairly decent way of trying to resolve disputes in my mind. But when we pull random people off the street and what do they think, they might well think, look, so you're a bridal shop and all of a sudden you're a medical device manufacturer now, you're trying to do good, we'll cut you a little more slack. Maybe a jury will think that, maybe not. It's a question of how public opinion and how views play out over the next few years as we struggle with the ramifications from this crisis. But so in reality, might there be a little bit of a difference in those subtle ways we just talked about? Overall, it shouldn't make much of a difference, though, whether you are an experienced medical device manufacturer or you are absolutely new to this game and you're still learning what the term medical device means, and what Class 1, Class 2, and Class 3 devices are, as long as you are falling within the definitions of covered countermeasures.
If a product is produced in connection with responding to the pandemic and is still on the shelves a year or two from now and is used in a non-COVID procedure, maybe an elective surgery or something like that, if a lawsuit is then brought that alleging that the device was defective and led to the plaintiff's injury, would that manufacturer still be able to assert PrEP as their defense because they were only making that material because of the pandemic?
Same caveat as before. My gut reaction is they would not be protected. And the reason why is not the timing, but let me talk about the timing in a minute. Not as much the timing piece of it as what, they're doing this for some other elective surgery, right? The point of the PrEP Act is to protect manufacturers from lawsuits that are being used to stem the tide of the pandemic, of the public health emergency. And so going back to my example earlier of the two patients, one who has a regular old flu, the one who has the COVID-19 flu, in rooms right next to each other in a hospital, the regular flu one can sue the manufacturer. Whether that's successful is a different story, but can sue the manufacturer, while the COVID-19 patient cannot sue the manufacturer. So I think in that example, right, if you're making a COVID-19 product that's being used for non-COVID-19 uses, then the PrEP Act doesn't protect you. Now, let me add, though, the very important piece to that, when there's a whole body of product liability law that we expect people to use products the way that they're intended to use. They're intended to be used, right? We don't use a car as a submarine. And then we also have the added defense of the learned intermediary, the surgeon who is there and who is improperly using a COVID-19 device for a non-COVID-19 situation. So don't think just because the PrEP Act doesn't apply that your company still won't have good defenses. It just might not have that immediate motion to dismiss defense that the PrEP Act has. Let me move over to the other piece of that question because it obviously raises a lot of points, and that is the time frame. So part of the PrEP Act is that the Secretary has to declare what is the time frame for COVID-19 products. And Secretary Azar has done that already, and said it was from early February of this year out to 2024. And the Secretary may well extend that deadline. Deadline is probably the wrong word. Will extend that coverage period even longer. So, but that's the coverage period for which the PrEP Act, the use of a of a product under the PrEP Act applies. So hopefully that answers the three sort of different pieces of that question.
I think we have time for just one more question. It's sort of in the same vein there. And it's a question about whether intent matters when the product is being produced, or if it's just the actual use when the product is eventually used. So to clarify that, if a bandage manufacturer had been making bandages for decades and continued to make bandages through the pandemic and after and distribute and market as they always had, and one of their bandages was used to treat a COVID patient, and the patient later files a suit alleging a product defect that led to an infection, would they be able to assert PrEP as their defense just because their long-time product happened to be used randomly to treat a pandemic patient?
As I see the act, yes. So if your product is used in a broad array of fields, but for one particular circumstance it's used for COVID-19, as long as it falls within all those definitions of the PrEP Act, you're protected for that one narrow use, but not others. But to pull back from that piece to the first part of how you asked that question, there was the question about intent, and I think it's an interesting piece that it's whether you intend to use it as COVID-19 or not. That intent doesn't matter. What it matters is how it actually gets used. At least that's my interpretation of the PrEP Act. But to step back even one step further, this is saying the lawsuits are immune under the PrEP Act, or most lawsuits should be immune under the PrEP Act. So that means that the intent of the manufacturer doesn't matter. For those who are more familiar with how product liability lawsuits generally work, right, we have either strict liability or negligence. And negligence, we look at a reasonable care or reasonable standard, and strict liability is a little different. And under a strict liability regime, and this is just a normal product liability lawsuit, we say regardless of whether the manufacturer was being reasonable or not, was the product defective and unreasonably dangerous. And PrEP Act sort of preempts all of that product liability law, and I'm using that in the non-technical term, preempt, though it might be technically accurate, for COVID-19 covered countermeasures. That is, if it's a covered countermeasure, we don't care, negligence standard, strict liability standard, we're not looking to that. The only place where intent may fall in is for the snake oil piece of this, and that's the willful misconduct, because there must be some high level of intent that that you're selling snake oil. That those test kits haven't worked, will never work, and that you're just putting them out there on the market regardless. So hopefully that answers that question.
Jordan, thank you so much for this valuable and timely information and for staying over time for us to grill you a little bit. I think I can speak for all of our listeners in saying that we really appreciate your insights.
Great. Well, and thank you for letting me put this on.
Thank you for joining us. This concludes today's webinar.